council seek permission, issue number, proceed with issue number 3. Before the going of issue number 3, my lordship, will deed is validly executed. I am, according to section 63 of the Succession Act, when the creating of the building, at least with 2 witnesses are necessary, and when the proving the execution of will deed, according to 68 of the Indian Succession Act, at least 1 witness is necessary. In present case, sir, what happened? One of the witnesses, that is Shruta Malhotra, denied the signature in presence of testator. That's one of the case law I am peruse, lordship. When 1 witnesses are denied or not said, not remind the presence of the witnesses, that is will deeds does not valid, invalid. So that was one of the case laws, lordship.
What is it?
Kindly peruse, lordship.
What is that case law?
Lordship, I given the case laws. In para number 7, lordship, ARI 1981, in case laws said that it is true that even evidence is such considered testator in presence of testator, mere fact of the witness does not specially state that they attested witnesses in the presence of testator may not invalidate the document itself. It is showed, its case law shows that one of the person denied in presence of signature when creating the will, that is when evidence come before the court, and she Shruti Malhotra is denied.
Why the expert opinion is denied then?
Expert opinion is not necessary, lordship, because of clearly shows that she is denied the signature. And another one of the witnesses that is also present, Amit Mehta. Amit Mehta not come in the case cross examination. So when we witnessing the second witness, they will Amit Mehta said that this I presence of the signature made in before the testator. So expert is not.
Deal with your issues.
Yes, lordship. Issue number 4 is that, issue number 3 is that seal the cover and confidentially and NDA, that is non-disclosure of procedure. I have, lordship, I have made before the application honorable court proceeding the will deed before the sealed cover that the application allowed and framed these issues. Lordship, my humble submission is that the court has inherent jurisdiction and settled principle of civil procedure when adapted to prevent the prejudice, protect privacy, ensure the fair trial, and media sensitivity. In the lordship, in the case publicity, used publicity in the case. That's why I made the application for the sealed cover and sensitive document of the will. So one of the case law for this issue, sir, Naresh Mirajkar versus State of Maharashtra. In the case law held that the Supreme Court open justice subject to exception, and the court has lawfully restricted public access or disclosure where required in the interest of justice, fairness of the trial, and administrative of justice. So it is clear show that it does not violate the principle of open justice, lordship.
How it is you apply this principle in your case?
Lordship,
Then explain.
I made application for the honorable court to keep confidentiality and sensitive document, and court allowed my application. Court allowed application because lordship prevent the prejudice and protect privacy, ensure fair trial, and media sensitivity. Lordship, my case is very publicity. I am Sanju Khanna is very famous industrialist. That's why my case publicity. That's why I made my application for keep confidentiality of will. And sir, lordship, it's relevant case law, sir. The Supreme Court held that open justice is subject to exception, and court may lawfully restrict the public access. So in case, sir, made public access, so for the restriction of public access or disclosure of where required in the interest of justice and fair trial and administrative justice. Case is relevant for this third issue.
You see, this Shruti Malhotra stated that I have not seen other witness while signing the will deed. Are you clear? And second is that this testator Sanjeev Khanna
Yes, my lordship.
do not state in will deed
Uh,
that I have executed this will deed in presence of witnesses. When these are the facts,
yes, my
then
lord.
how your will can be relied? Two things are appearing here.
Yes, lordship.
What are required? The will must be executed at least in
At
presence
least
of
two
two
witnesses.
witnesses.
Yes,
Here, one of the witness which has been examined
yes, lordship.
says that I have not seen the another witness
Yes, lordship.
signing the will deed.
Yes, lordship.
One thing over.
Yes, lordship.
Second is that
Ah.
this Sanjeev Khanna
Yes.
in his will deed not stated that I have executed this will in presence of witnesses. Then how the essential ingredients has been proved?
Lordship, I want refer to one case laws.
No use of case law when necessary requirements are not proved. Then how case law will be
Lordship,
used?
Shruti Malhotra is lack of memories and denies the execution signature in mint. That Lordship, one of the case law Janki Bohor versus Narayan Kadam. In this case law held that while the execution section 68 required at least one witness to be called. If witness failed to prove execution, lack of memories.
About in the presence of, Mr. Khanna was alive, that time he did his will.
Yes,
Right?
Lordship.
So the concern is when he make that will, that time that will was executed in the presence of any witness, and that type of statement is mentioned in that will or not.
Not, madam. Not.
Then that is a question.
Your will is
Then
doubtful.
your will is not valid.
Lordship, one of the problem is that she only Shruti Malhotra only one witness is.
That question comes later. Comes to the primary things.
Lordship, not aware of this issue.
Take. Proceed.
Lordship, proceed with issue number 4. That is, issue number 4 is that interim relief and preserving the asset. My humble submission is that plaintiff is not entitled to interim relief because of Lordship. Injunction under Order 39, Rule 1 and 2 CPC required 3 essential elements. That is, prima facie case, balance of convenience, and irreparable loss. That is, in present case, Lordship, plaintiff challenged the rest or mere allegation forgery and suspicious without any strong prima facie proof. That is not entered, this case not prima facie case. Second is that balance of convenience lies in my favor of, that is, defendant. House Lordship granting freezing order appointing the resource without grave irreparable distribution among the my business and investment and contractual obligation forming the estate, and no any irreparable clause to plaintiff because of Lordship. No any solid proof of the defendant to selling or transfer or aside the asset now, saying that some accounts were wiped out. There is no any apprehension of for granting injunction for the plaintiff. It is a humble submission that plaintiff not come with clean hand. That is not entitled to interim relief. That is injunction. Lordship, one of the case law in, for injunction, granting injunction, I refer to my page number 60, 4.5. Dalpat Kumar was said, Parla Singh. In this case, law held that court the granting injunction cannot be granted on basis of only sympathy and unsustainable allegation. Only made allegation is will is not valid, not valid, not valid. That is my humble submission that plaintiff not on only on basis of not made entitled injunction for the allegation. It is my humble submission. Lordship, Counsel seek proceed with 5th issue.
Is time permitting? Time over. ठीक है.
Lordship, 5th issue is that my humble submission is that minor plaintiff by their mother Kajal, next friend, either not automatically or unconditionally under order 13(2) of the CPC, while the natural guardian merely act as a next friend without formal requirement of court. Such entitled in present case, Kajal Khanna personally and litigate interests are clearly intervened with, and potential adverse treat for order 32 clause 9 said that disqualification of next friend because Kajal are adversely affected the.
Is it proved that she is having this type of interest?
Yes, my lordship, because of challenging the will deed on the basis of the huge amount, that is 30,000 crore rupees. She also,
She is looking for the better interest of the child, and that is a basic right of that mother.
lordship, only, you challenge only the movable property, that is will deed, not claim the my industry, Sanjeev Khanna industry, that is amount, that is also adverse benefit, take the benefit, that is as a next friend. That is one of the adverse interest.
But Mr. Sanjeev also wants to protect the interest of the child,
Yes, already made out the trust.
right?
Yes.
He already made the trust.
Yes.
And through that trust, he wants to protect the interest of the child.
Yes, lordship.
So his interest is only that mother is protecting. So what's wrong in that?
Lordship, in present case that Kajal Khanna personal and litigation interests are clear.
That's what we are asking. What that interest is? You are saying that alleged interest. What interest is? What that?
She taking the benefit amount of the 30 crores.
Is it proved?
Yes, lordship, in facts of in Boucher's case. Lordship,
Facts cannot be referred as a matter of evidence.
lordship, in the case in present competition in held that account statement in on record, that is opening balance of the
It is already public.
Yes, my lordship. My lordship, for this question, my humble submit that suppose she is acting next friend, she claim for the only will of the immovable property. She cannot take the.
She is just working for the best interest of the child.
Yes, my lordship. But also, sir, adverse interest take benefit of that Easter.
Just tell me the answer for the adverse benefit you are talking. You are arguing, you are quoting a lot of matter for adverse benefit. What is adverse benefit? And if that adverse benefit is there, whether that adverse benefit is proved?
Lordship, not proved, but I am saying that she is taking the advantage of this estate, that is amount, huge amount. So lordship, she act as a next friend, but she cannot claim assets. Lordship, with the permission, prayer.
We already know the prayer.
Yes,
Much obliged, lordship.
okay.
No rebuttals now. No rebuttals. Yeah.
Sufficient time given.
Yes, thank you. हाँ, सर आ गए। अच्छा, ठीक है। ते लवकर